C'est un grand plaisir d'être ici. Merci pour l'invitation. Je change en anglais. Yeah, so we're not going to discuss the tokenization of companies in a strict sense, but we're getting as close to that as we can. In fact, who am I? I'm a member of the advisory board of the CMTA. I'm also going to explain what is that. And in my daily job, I'm a partner with Hamburger, which is a law firm based in Zurich. I'm a professor at the University of St. Gallen in eastern Switzerland. Today, I'd like to introduce to you the CMTA, what the organization is, what it does, explain what the standards that the organization has published are. Then I'll explain what is really a small corner of the entire crypto economy ecosystem, namely the tokenization of securities under Swiss law. I'll get to what I exactly mean by that, of course. Then I'll like to present a few benefits and use cases of tokenizations, and then I'll walk you through the process that the CMTA has developed for tokenizations. First, who is the CMTA and what is it? Its full name is the Capital Market and Technology Association. It was established 7 years ago by a Geneva-based law firm, actually, and a few other organizations. And it's a non-profit, it's an association. Its purpose is to promote the spread of digital ledger technology, blockchain technology in capital markets. It's really a volunteer organization, so we have one paid employee and the rest of us is working for free. Currently, we have around 40 members. It's usually corporate members from across Switzerland's finance ecosystem, so all major banks are on board, most major law firms, many technology providers, the two stock exchanges as well. And the most important thing that the CMTA does, besides evangelizing about the technology, is publishing standards for tokenization of securities. Currently, we have, well, it depends on you count that, 4 standards, four legal standards, 1 technological standards. The first standard was a standard for the tokenization of equity securities, that is, shares and instruments that are similar to shares, like non-voting securities. Then the second one is actually a technical standard, the CMTA. It's a standard describing the features that a smart contract needs to have so you can validly tokenize securities with it. It's blockchain agnostic, and there are reference implementations for Ethereum and Tezos. Then we have a digital assets custody standards for custodians, an anti-money laundering standard, and the youngest baby in the family is the standard for the tokenization of debt securities. I'm aware the type is a little small here, but I'll get back to the most important standards a bit later in the presentation. So what do I mean by tokenizing securities under Swiss law? If you have a technical background, the term tokenization might sound a bit unfamiliar to you because it's not a technical term or a technology term at all. What we mean by that is the process of linking a token, in a technical sense, with a security, a financial asset. And this is a legal process, essentially. We could also think of tokenization as another layer. You have a technical layer with the blockchain and the token, and then the smart contract above it. And then the legal layer declares the token as something like a representative or to be associated with the security, like the share or a bond or a structured product. And so the tokenization process is about really linking a token with a security, and Swiss law has been allowing that since 2021. Switzerland was one of the first countries in the world to establish that, and even more astonishing, this piece of legislation was passed without any no votes in the Swiss parliament. This is something that never happens except when they decide to increase their remuneration. So the Swiss law establishes some requirements as to the blockchain and a bit less as to the tokens, but it's interconnected, of course, that have to be satisfied so you can validly link a token with a security. The most important of these requirements is that the system, the smart contract, has to be designed in a way that token holders can transfer their tokens to another person without approval of the issuer of the security, typically of the company. Then the blockchain, the digital ledger, has to be designed in a way that makes it very hard to falsify it, to forge it. This is not an issue with all modern blockchains. Then there are certain documentation requirements as well. This is something of a remnant from the classical law of negotiable instruments, like, think of share certificates that are printed on security paper, which was the basis dating back to the Middle Ages to do all the securities law we have today, of which the tokenization is just maybe another evolution. Now, to summarize tokenization in the graph, it means this: linking a token and a security. And the law uses the word ledger-based securities, but what it means is the same thing as a tokenized security. So in a way, or maybe to put it differently, if you have print the share on paper, on security paper, and the director signs it, then in a way you have linked the paper with the share, with the membership right and the dividend right in a company. And if you then transfer the paper, you transfer the membership right. Replace the paper by the token, and now you see what this is about. Benefits and use cases for tokenizations. The CMTA doesn't exactly know who is using the CMTA, who has issued token using the CMTA and has linked these tokens with a security. The reason is that it's all open source. Nobody knows who's using it. That's the way it should be. There have been various projects, smaller and bigger, with various asset types. There has been, proof of, it's actually live, a issuance of equity securities, or actually several of them in Switzerland. Then several parties have tested the issuance of debt securities. Notably, UBS has issued a tokenized bond, and there also tokenized notes have been issued, which is something very similar to a bond. Finally, there are quite a few proofs of concept that you can tokenize structured products, which are these financial instruments for, let's say, more speculative-minded investors that, let's say, consist of a basket of shares, and if one of the shares exceeds a ceiling, then you get payoff X, and otherwise you get something different. So when you look at the map, not surprisingly, most of the existing cases came from Switzerland. In Germany, another version of CMTA has been generated, which complies with the German tokenization laws. Germany was a bit slower than Switzerland, but now it has a similar law too. Liechtenstein has it too. Singapore apparently enables tokenization of shares as well. They appear to have used the CMTA. And there have been uses in India too. Now, what are the benefits of tokenizing shares, equity instruments, membership rights in a company? Legally, what we struggle on a daily basis, especially as M&A lawyers, as I am, is the chain of title to a share. If the company is young, it's usually no problem. Somebody has incorporated the company. At the incorporation, the company issued shares. Often they sit with the founders, so no issue. But imagine a company that's 80 years old, where shares have been split and maybe at some points issued on paper, and then the paper has been lost and the shares have been reissued, and then the shares have been transferred. Maybe there's a missing signature, and then the shareholder died and his heirs acquired the shares and transferred them on. And if you want to ensure that the guy who's holding a share now, that maybe that wants to sell the share to your client, is really the shareholder, you have to trace back all this chain until 80 years ago to be sure that the current shareholder is really the owner of the shares. Often this is impossible. Also, very often this is never an issue because there's nobody that disputes ownership, so you just live with the risk. But it's deeply unsatisfying, deeply inefficient. And if you tokenize shares right upon their coming into existence, by definition, you have the record on the blockchain, and you can track the change of title. Yes.
My understanding is that every company must have a ledger. Well, except for a public traded company, they must have a ledger of their shareholders. But if you're evoking the case of where like shareholder dies and then they pass it over to they take over the control of the token.
Yes.
You haven't KYC, like the company doesn't know the identity of whoever taking over the token.
Okay, that's all correct. Where do I start? Yes, even if you have tokenized shares, you can, in some ways, acquire a share off chain, like in succession. If I die and my son or my wife will inherit it, and it's off chain, right? But if my wife then controls the wallet, and if she can prove that she's my heir, there's a legal mechanism for that, then she's the new shareholder. You're also correct that companies have to have their own share register, but that register isn't conclusive evidence that the people mentioned there are the shareholders. It's better than nothing, but it's not authoritative, right? And so technically a shareholder that sells its share, if the shareholder doesn't tell the company the record is incorrect, the acquirer wouldn't be recognized as a shareholder. So the acquirer couldn't appear at the shareholder meeting without proving that he's validly acquired the shares, for sure. In a private company, the acquirer also would have difficulties to get the dividend. But the share register doesn't solve the issue with the change of title at all. Yes. Well, thank you for this question. So transfers themselves can also be simplified. If you don't have shares on paper, you have to have a wet signature or a qualified electronic signature to transfer shares. And there are many mistakes happen. Many times people forget to sign, and sometimes this creates these issues with the chain of title, and also it's a bit of a hassle too. This is simpler with tokenized shares. And finally, you often have contractual arrangements where you would, let's say, force a sale of shares. For instance, if you're the founder of a startup, you give your employees shares, but if they leave, you have a clawback. If an employee is fired, they wouldn't necessarily cooperate in handing back their shares, and so you might be interested in a mechanism where you could force that transfer. You can do that through an add-on to a smart contract where you've tokenized shares. Our technical committee has developed such an add-on. I don't think it's public yet, but they're working on. Well, they're finalizing, I think, in the background. And similarly, most shareholders' agreements have, let's say, a drag-along clause where all shareholders have to sell their shares to a third party if, like, the majority of the shares are sold in an exit, right? And there, it's under law, it's a bit difficult to implement the mechanism where you don't need every shareholder's cooperation to fulfill their obligations under the drag-along. So what could come in handy is a mechanism where you can just force a transfer of tokens without the intervention of the shareholder. In terms of financing, I'm not a finance specialist, but there's, I think, at least a nascent market for tokenized securities. People find it just cool to acquire tokenized shares, which is something they couldn't do before until a few years ago. And this could also be an advantage. Then operating costs, financing costs could be reduced. You need fewer intermediaries. If you have a larger shareholder base, there are special service providers that handle your shareholder base for you, and their ambition is to digitize everything. The limit for that is transfer of shares. So if you don't have tokenized shares, you still have to have these wet signatures, and it's outside the electronic records. And so integrating tokenized shares in these share register, shareholder management systems has its benefits too. We mostly see use cases for tokenized shares in the private market, meaning in companies whose shares are not listed on a stock exchange. The reason is that for listed companies, there's already an infrastructure. It's also mandatory to use 6 SIS, a central securities depository, if you want your shares to be tradable at the stock exchange. And theoretically, you can even tokenize shares that are then listed on a stock exchange, but you'd have to deposit the tokens with 6 SIS, which is a bit pointless because then the tokens would have to be immobilized for as long as the shares are traded, which doesn't make any sense. That's not why you tokenize shares in the first place. But private companies, like I said, startups, and you would be surprised, or maybe you know already, that many startups, 5 years plus into their existence, they can have hundreds of shareholders. They need to manage their shareholder base. It helps with incentive plans. Fundings may be easier, though securities laws still apply. This is also maybe important to bear in mind. The fact that a company offers tokenized shares for investment triggers a potential obligation to publish a prospectus. If the company makes a public announcement or markets the shares to more than 500 people, it's a bit like an IPO, just without the public, right? But apart from that, it could be easier, and also tokenized shares may themselves have some intrinsic attractiveness. Now, on tokenized debt instruments, like I said, there's a newer standard for that. It's only been published a few months ago, maybe even less so. Interestingly, there has been a pilot project by one of the largest Swiss asset managers, Pictet, in which they took existing bonds, tokenized them, and then they could fractionalize the bonds and book them into the custody accounts of customers, which is something you cannot do with bonds that are just normal book entry securities. You could trade and settle bonds and notes and other debt instruments without intermediaries. What's currently still a challenge, but I think one is close to a solution, is the money side of a transaction in a bond. I mean, if you sell a bond, you very much like to get your purchase price somehow, and digital central bank money might be a solution to that, or of course stable coins. But there, I think the market is not where this will lead to widespread adoption, but I think everybody in the market is aware of the issue and is working on it. Yes?
What are the restrictions of whom I can transfer my shares to? If I receive tokenized shares, what are the restrictions on whom can I sell them to or transfer them to?
Under Swiss law, you can sell your shares to anyone. You just have to be careful that you don't offer them to the public, right? But if you make an advertisement, then it's a public offering. Then you have to publish a prospectus, etc. Don't do it, right? Okay. But bilaterally, there's no restrictions. I wouldn't necessarily, I definitely wouldn't sell a share to an American resident because their securities law is a bit stricter.
There can be some shareholders agreement that forbid the sale of shares.
What was that?
Shareholders agreements.
Yes.
In the status of the company that restrict the sale of shares, that you cannot sell them to anybody.
Well, yes and no. Yes, some companies have transfer restrictions. You have to obtain board approval for the transfer. If the board doesn't react within 3 months, it's deemed approved. But there have to be, in the Articles of Association, there have to be specific reasons for which the board can reject the transfer. But if there's such a reason, the board could reject the transfer flat out. And in most cases, even if there's no restriction, the board could decide to repurchase the shares themselves at fair market value, though. Yeah, that's right. And this is the same for tokenized shares too. The new equity standard, we've updated it this year, also contemplates this mechanism of transfer restrictions. I think it works via a whitelist, and as long as somebody's not on a whitelist, then the company has to sign off the transfer, and only then the token becomes transferable. Did you want to say something? No? Okay, sorry.
It's okay with question now. You want us to wait at the end, or?
But no, go ahead.
No, I was just wondering how that works in terms of KYC and
yeah, good question.
Tax evasion, money laundering. I'm all for this kind of stuff, just like because I'm a kind of a libertarian. But I'm just thinking, if I can sell my tokens to anybody, for example, how does that work from a tax point of view? If I own tokens of a company, I would declare that as an asset I own.
Yeah.
Sell it, make a profit. That would be a capital gain with no tax, I imagine.
Yeah.
All of this is true, right?
I think so. Yeah. Don't rely on it, but
no. I understand. So
it's not. The tax treatment of token. The tax treatment of shares is the same whether or not they're tokenized.
Okay.
Yeah. KYC, as an individual that is selling a share, I don't think you have a KYC obligation. You don't have to check where the money comes from. If you're a financial intermediary, yes, you have to. It does create some headache to the CMTA because there only has to be one bad apple in the cart, and it could tarnish the reputation of the whole thing. And so we're taking a conservative approach here, and the standard, which nobody has to comply with the standard, but those who want to comply with it, the standard is a bit stricter than the statutory requirements in terms of KYC. So investors would have to declare their ultimate beneficial owners before they can acquire a tokenized share, which is not mandatory under Swiss law, but we thought it's prudent to be a bit on the conservative side of things here. Usually you don't only have to declare your disclose your beneficial owners if you are looking to acquire more than 25% in a private company. Yeah.
Thank you.
Okay, and finally, settlement can be, depending on the blockchain, very quick. And in public markets, we still have T+2, so 2 business days from the trade execution date. You settle the trade. In the US, it's now T+1, but still it's +1. Now, last part of my quick presentation, how to use the CMTA standards for tokenizing shares. Like the blue one is the share tokenization standard, the orange one is the debt tokenization standard. Maybe to explain again what is what. So Swiss securities law defines as debt securities any securities that are not equity securities. So equity securities is a narrow concept: shares, non-voting shares, profit sharing certificates, basically these 3 things. Everything else, all other securities are debt securities, so bonds, notes, structured products, any other types of derivatives. It's all debt securities because it's essentially a contract between the issuer and the security holder. So you can use these. Then there's the CMTA, and then the CMTA has established so-called certification schemes. Legally, it's a guarantee mark, I think is the English term. It's maybe you remember. I think it's a bit like an AOC for wine or other agricultural products. That the way it works, it's like a trademark, and it's owned by somebody, in our case by the CMTA, but the use is regulated by regulations established by the owner, and these regulations define who can use the trademark. And the CMTA rules say that companies can use these trademarks here, so it's like a stamp certifications, if the companies have followed the procedure for tokenizing their securities defined by the CMTA. So it's optional. Anybody can use these standards and, of course, use the CMTA and tokenize securities without having to go through that process. In that case, they just cannot use these trademarks. It would be a trademark violation, right? But the standards are very open for use by everyone. But those who want to signal that they've actually compliant with the standard have to go through this process. So it starts in a preparatory phase. You would need to select the service provider. There's a list on the CMTA website of companies that do that. These service providers are technical service providers that are able to deploy the smart contract and create the tokens. And you have to retain a legal expert that gives some legal confirmations and prepare the tokenization. It includes some corporate steps that I'm not going into today. Then you have to file an application form with the CMTA. There's also an application and processing fee. The CMTA isn't planning to get rich with these fees, but sort of contribution to its costs. And then the tokenization is a process then where you would, if you issue shares, you would typically increase the capital of the company, issue the new shares, and by board resolution, the board would decide that to link the shares with the token. And as soon as this token has been created by the deployment of the smart contract, the tokens and the tokenized securities come into existence. And this is basically the closing of the transaction. You also have to procure a confirmation by the service provider that this has happened, and a legal opinion by the legal expert. And after that, one can use the CMTA trademark and has to comply with the trademark regulations. There's also a renewal on an annual basis. Again, it's not mandatory, so nobody commits to renewing it. The only consequence is if an issuer doesn't renew the certification. Of course, it's an easier process, by the way. So the only consequence if an issuer doesn't renew the certification is that it can no longer use the certification mark. Then, same process, but seen from the perspective of the company. This one was the perspective of the CMTA and of the advisors. This is the company perspective. So you have a corporation, you have to make it ready legally to tokenize shares. Then the smart contract has to be prepared. And if necessary, a prospectus, often not, hopefully. Then the company has to issue the shares. This is a process governed by Swiss law, of course. As a matter of practicality, you need to gather the investors' wallet addresses or their custodians' wallet addresses. And finally, the tokenization happens through a combination of the board resolution and the deployment of the smart contract and the creation of the tokens. And then the tokens would be allocated to the shareholders. Yes?
Is it an all or nothing solution? As in, does every shareholder need to be on board with this? Or can the board issue shares for 67% of the company, for example?
Yes.
And then the rest remains wet signature?
It's the latter. Yes, it's the latter. The board can decide which shares to token and which to tokenize and which not to tokenize. I'm not sure how much sense it makes not to tokenize all shares, but it could. Yeah, it's possible. The only thing is they're not really fungible, tokenized and non-tokenized shares. You either have one sort of the or the other sort of share.
But what happens with the shares that have been tokenized?
Well,
do they still exist as a share? Because in Switzerland there is the law of Wertpapierrecht. I don't know how you say it.
Negotiated instruments, yes.
And this one is quite strict. I mean, do the share, when they are tokenized, do they disappear as a part of the value of the company, as a part of the ownership of the company?
No, not at all. It's a very good question that you're asking, because it's actually one of my favorite topics. There are three meanings of the word share under Swiss law, even under Swiss corporate and securities law. The first meaning is it's a fraction of the share capital. The second meaning is it's the bundle of membership rights, membership in a company. Of course, it's linked to the fraction of the share capital. You cannot separate the two. And the third meaning, and that this is something you can actually separate, is the form of a share. I think, and historically, I think the first corporations in the 17th or 18th century, they only issued shares on paper, and if there was no paper, I don't think there was a share. But that's a bit outdated, the view. But unfortunately, our corporate law sometimes still reads a bit as if this was still the default. But even in that case, if you destroy a paper share, your membership right doesn't evaporate. The share is not cancelled. In fact, then you have to go to a court and prove that you've destroyed it, and then you're reinstated, or the company can reissue a share certificate. In the case of a tokenization, if you tokenize a share, it's just a token instead of paper, or instead of nothing, instead of uncertificated shares. And so what is the share then? It's still membership right, it's still a fraction of the share company, and the form happens to be a token. And if you burn the tokens, if you destroy them, the shares keep existing. Well, share in the sense of a fraction of the share capital and membership right, but they're no longer tokens, so they become uncertificated shares. And if you want, or if the company wants, it can issue paper certificates, and it's still the same share, but it has taken a different form.
This means many companies now, they put their shares at SIX Group, and they get certificates for that. It's located there. Meaning, if you tokenize, do you still keep the certificate of the shares?
Nope.
Inside?
No, you cannot.
Out of SIX.
You cannot. Tokenization has nothing to do with the SIX, and has nothing to do with paper share certificates. In fact, it's mutually exclusive. You cannot have the same share in the meaning of a membership right represented by both a token and paper. And you don't have to issue paper and deposit the paper somewhere so you can tokenize shares. This is what the mechanism you're referring to does exist, but it exists for the creation of so-called book entry securities, Bucheffekten, which is basically shares that are in the banking system, and that can be transferred from one custody account to another custody account. But there, since around, 30 years ago, even their companies no longer deposit paper shares with SIX SIS. It's just dematerialized shares. Yeah. Lastly, debt securities. Like I said, it's a very broad concept. The standard is designed in a way that non-Swiss issuers can use that too, if the law that governs them allows them to do so, which we don't know. Well, we hope is the case. The standard outlines how to link the terms and conditions, it's like the terms of the contract of this debt instrument with the token. So you can see what these terms and conditions are. And the standard also makes recommendations on what information has to be included on the blockchain. So I'm already at the end of my presentation. I'm very happy to answer further questions from you, or simply chat away. Still around for, I have to go in all 25 minutes, but I'm here until then. So thank you for your attention.
Thank you. Just saying, don't have any questions.
So so basically what you do, the CMTA is a quality kind of standard or for tokenized securities?
Yes.
Yeah. Okay. I
yes.
want to make sure about that. So
it's a very good
if I do one of those and I have you as a standard in regards of my customers or etc., this is not a guarantee, but a sign of seriousness and compliance.
Yes.
Okay, great.
Perfect. Then let's go for a drink.
Sure.
Yeah.
Okay.
Pleasure.
Okay.